Hi, this is Stuart Solon with the Solon Law Group, and today I'd like to talk to you about the crime of disorderly conduct in Arizona. Now, this is defined in statute as ARS 13-2904. This is a common crime that we often see because it can be interpreted so broadly by the police and the prosecution. It can be used to cover a wide range of activity that sometimes are charged when the police can't find any other crime to charge somebody with. Now, what this means is that sometimes disorderly conduct charges can actually be pretty weak and pretty open to interpretation as to whether what the person is charged with is actually against the law. It's just this very broadly defined crime. So in this video, we're going to talk about what disorderly conduct is, and we're going to start off by defining the statute, then talking about the penalties you could be facing for disorderly conduct, and finally we're going to be talking about some defenses to that crime that could be used to potentially help get you a favorable outcome if you have been charged. First off, it's important that you understand that disorderly conduct can be charged as either a misdemeanor or a felony. In this video, we're going to be talking about misdemeanor disorderly conduct. So let's dive right into it, first by defining the statute. All right. According to ARS 13-2904, misdemeanor disorderly conduct occurs when a person, with the intent to disturb the peace or quiet of a neighborhood, family, or person, or with knowledge of doing so, commits certain acts discussed in the statute. We'll get to what those actions are in a little bit, but what I want to do here is look at that language that I just read to you and point out the significance of it, okay? So there are two important elements in this sentence I just read. The first is that what this language does is define the state of mind that a person needs to have in order to commit disorderly conduct. Do you see that the statute talks about an intent to disturb the peace or knowledge of disturbing the peace? This is also what's called mens rea, but what it does here is that it shows you the mental state that a person needs to have, that the prosecution needs to prove in order to show that a crime was committed. Requiring intent and knowledge is important because what this means, when an attorney reads it, is that another type of mental state is recklessness. So recklessness alone it's not enough to prove disorderly conduct. The state needs to show some degree of knowledge or intent that the actions committed by the individual charged with disorderly conduct would in fact disturb the peace. So the second important thing that this opening part of the statute tells us is that the peace or quiet of a specific neighborhood, family, or person needs to be disturbed. So this is like that saying, if a tree falls in the woods and if nobody's around to hear it, does it make a sound? Well, if you make an unreasonable noise or disturbance, but nobody's around to hear it or to see it, then according to the disorderly conduct statute, no crime has actually been committed because nobody's peace has been disturbed. So yelling on its own, that's not going to be disorderly conduct unless it disturbs somebody's peace. So whenever the police are looking, investigating a crime of disorderly conduct, or the prosecutors are looking to charge somebody with a disorderly conduct, what they should be doing is taking into account the suspect's mental state, as well as who was supposedly affected by the disorderly conduct. Okay, so now that we've talked about that opening part of the statute, let's go into and talking about the specific actions that would actually constitute disorderly conduct according to the statute. And for misdemeanor disorderly conduct, there are 5 different categories of actions listed in the statute. The first is if a person engages in fighting or violent or seriously disruptive behavior. So fighting and or violent or seriously disruptive behavior. This is the subsection of the statute that we see most often in disorderly conduct charges. And the reason for that is, as you can see how it's written, it's very broad. Especially the terms violent or seriously disruptive behavior. I've seen the police charge all types of things under the category of seriously disruptive behavior. Often, things constitute seriously disruptive behavior. They will usually involve verbal arguments that are taking place in public and are very loud. You know, a classic example of this would be 2 people who are at a restaurant. Maybe they start a verbal fight. They refuse to stop. The police get called. The police come to the restaurant. And then if they're still arguing and yelling and people testify that their peace was disturbed, then there's a good chance those people are going to be charged with disorderly conduct. That's a classic example, and I think that's the type of thing that the disorderly conduct statute was probably meant to deal with. But you can also see a lot of other instances where people are charged with disorderly conduct when maybe they're fighting in their home. They don't think another neighbor hears, but maybe the walls are thin. Somebody hears, and then one of the people winds up being charged in that fight with disorderly conduct. So it's very broad, and a lot of people can be caught up in that section, in that subsection of disorderly conduct. So now let's move on to the second type. And the second type of disorderly conduct is when somebody makes an unreasonable noise. So for example, if you were in a quiet neighborhood late at night, and then all of a sudden you start to blare the radio at top volume, and the police and the radio is so loud that it might even be a noise violation, then that could probably constitute disorderly conduct as well. With this subsection of the statute, though, the question becomes what amount of noise is unreasonable? And this will often depend on the circumstance. Let's take the blaring radio, okay? If you do it in the middle of the night in a quiet neighborhood, that could be disorderly conduct. But if you go to a tailgate party and you show up in the parking lot, you turn on the radio really loud, then in that situation, it's not necessarily unreasonable to have that level of noise. It very much depends on the circumstances, and ultimately, a judge or a jury is the one who's going to decide what is or is not unreasonable, given all the different facts surrounding the case. So let's go on to the third category now. And this is if a person uses abusive or offensive language or gestures to any person present in a manner likely to provoke immediate physical retaliation by such a person. Okay, so with this statute, honestly, we don't see charges too often under this specific subsection because it's a bit more specific. It's a bit harder to prove. And if a person's committing conduct that falls under this subsection, it probably could fall under seriously disruptive behavior as well, which is a much looser definition and easier to prove. You'll notice in this subsection that making an offensive gesture by itself is also not enough. So let's say you're driving down the street, somebody cuts you off, and you flip them the finger. All right, that's an offensive gesture. We can all agree that's an offensive gesture. It's not kind, right? But it's also usually not something that's going to provoke a person into immediate physical retaliation. In other words, make them jump out of the car and start to go up and try to hit you. That's not really a reasonable response. So we wouldn't expect to see something like this charged unless the gesture was really out of line and really offensive, depending on the context of where it happened. Now, the fourth category is when somebody makes any protracted commotion, utterance, or display with the intent to prevent the transaction of the business of a lawful meeting, gathering, or procession. So also here you see that a protracted commotion isn't enough on its own. This has to be done in the context of some sort of lawful gathering. So an example of this would be if a person takes a megaphone to a town hall meeting or a city council meeting and starts screaming at the council members. Okay, well then that would be an example that would fit under this subsection because the person is trying to disrupt this lawful government meeting. And here, notice it doesn't matter whether what the person says is offensive. I mean, maybe the person's making really good points in this meeting, but if it's done with the intent to prevent the business of the meeting, then it would fall under this subsection of the statute. They could, kick them out of the meeting and then get them charged with disorderly conduct potentially. So now the final category of misdemeanor disorderly conduct is when somebody refuses to obey a lawful order to disperse issued to maintain public safety and dangerous proximity to a fire or hazard or any other emergency. So this is when if there are a group of people standing around, let's say a burning building, and you're getting in the way of the firefighters, so the police tell the people to, move along and disperse, and then somebody doesn't, well then that can be disorderly conduct. All right, so we've gone through a lot. Those are the 5 different categories of misdemeanor disorderly conduct. So now let's talk about the potential punishment you could be facing if you're found guilty of one of these crimes. Disorderly conduct is a Class 1 misdemeanor in Arizona. This is a category of crime, and it is the most serious type of misdemeanor. It's punishable by up to 6 months in jail, up to $2,500 in fines, plus surcharges, which can essentially double the fine, as well as up to 3 years of probation. The court can also order community service or certain classes as a term of probation. Also as a term of probation, they could order that you're not to possess any guns during that time. So if you're a gun owner, that could be something that could be an issue for you. Now, what I just read to you, that is the worst case scenario. Usually nobody's going to get the maximum penalties, especially if they're a first-time offender. It's not saying it's not possible, but usually that's not going to happen. But it could go up that far. And now, my firm, we've been able to successfully get disorderly conduct cases pled down or dismissed entirely, depending on the circumstances and if the person being charged especially has no prior criminal history or nothing serious. Then we're very successful at avoiding jail time and sometimes getting cases dismissed. Now, everything, of course, depends on the specific facts. Your case might be different. Okay, so now let's talk about some common defenses to disorderly conduct. We touched on this a little bit already, but one of the biggest defenses is that there was no intent or knowledge on the part of the person who allegedly committed the crime that they were disturbing somebody's peace. Now, if disorderly conduct is charged against a particular individual as a victim, let's say, for example, the state accuses Joe of disturbing victim Bob's peace, then there's an Arizona Supreme Court case which says that the state has to show that the defendant, Joe, knowingly disturbed the victim's peace or intended to do so. So if the victim, if Bob doesn't go to trial to testify that his peace was actually disturbed, or if there's no other evidence that his peace was disturbed, or that the alleged perpetrator, Joe, intended to disturb his peace, then the state doesn't have enough to show that disorderly conduct occurred. Another main defense is just looking at the facts of the case, because disorderly conduct is a very fact-intensive statute. It requires the state to prove beyond a reasonable doubt often that conduct was in fact seriously disruptive. Well, that begs the question, what does seriously disruptive mean? The prosecutor or the police, they might have one idea of what that means. But if the prosecutor's not able to convince a judge beyond a reasonable doubt that the defendant's behavior was actually seriously disruptive, or that a noise under the circumstances was actually unreasonable, then that should result in a not guilty verdict. The state has to prove that beyond a reasonable doubt. So now, what do you do if you're watching this video and you've been charged with disorderly conduct? First thing is, I definitely recommend, whether it's me or somebody else, you owe it to yourself to speak to an attorney about your case. Most defense attorneys will offer free consultations. My firm certainly offers free consultations for criminal defense matters. So if you want to know more about how the statute can apply to your case and what a defense attorney such as myself might be able to do to help you out of this situation, just pick up the phone, schedule a consultation. Each case is different, so no attorney can guarantee you any results, but I can tell you that in the past, I've dealt with a lot of cases that involve disorderly conduct, and we've been able to get good results for our clients, getting cases pled down, getting cases dismissed. So if you want to know more about your case, pick up the phone. I'm happy to talk to you, and we're happy to help and see what we can do to help you with your situation.